Let me know once. Are we live? Good afternoon, ladies and gentlemen. This is Dr. Olu Asekun here again. Welcome to another week of our weekly podcast. Today, as you already know, we are continuing with the series coming to live and work in the United States series. We started this series some weeks back. I believe we spent about 4 or 5 weeks on this topic. So today we are continuing with the series coming to live and work in the United States series. Thank you. So welcome to Dr. Olu Asekun podcast once again. This podcast is every Wednesday, 12 p.m. Central Standard Time. That is 6 p.m. Nigerian time, 1 p.m. Eastern Time, 10 a.m. Pacific. You are welcome. So we continue with the series, but today we are discussing humanitarian benefit. We've discussed, I believe we started from applying for visa, talking about admission, CBP admission, talking about change of status. We've spoken about National Visa Center. We've discussed a lot of things. So today we are discussing humanitarian reliefs. Now, there are so many humanitarian reliefs. When we say humanitarian, these are reliefs that is generally not based on merit, but is discretionary. These are reliefs that the government, in their own goodness, decide to give to eligible people based on a case-by-case basis. Now, one of the major differences between other reliefs and humanitarian relief is that for other reliefs, generally there are statutory requirements, there are eligibility requirements, and there are listed factors, positive and negative equities factor that are taken into consideration in the adjudication of this benefit. And for this benefit, it has to be the standard has to be applied generally. However, in the case of humanitarian relief, it is usually based on a case-by-case basis because they don't use the same standard for everybody. It is usually on a case-by-case basis for humanitarian relief. Now, examples of humanitarian reliefs include asylum, deferred action, both in court and with USCIS. Remind me of other humanitarian reliefs. Yeah, I've mentioned deferred action. T-visa, U-visa. Yeah, T-visa, that is a victim of trafficking. U-visa, victims of criminal activities. And of course, maybe even, I'm not sure VAWA can be categorized as humanitarian relief. No, it's not. I don't think so, because VAWA has a different, VAWA is statutory, is an act of Congress. Humanitarian reliefs are usually based on either act of Congress or executive authority, but they are decided on a case-by-case basis. That is one of the major differences. VAWA is not decided on a case-by-case basis. VAWA is decided based on the three requirements of the statute. Must have been married to a U.S. citizen or a permanent resident, must have been abused, and the beneficiary or the applicant must be a person of good moral character. That is the statutory requirement. So, and that is applied broadly to every applicant. But for humanitarian relief, they are adjudicated on a case-by-case basis. Two different applicants can present exactly the same documentation and evidence, and one may be granted and the other may be denied. So those are some of the unique differences when it comes to humanitarian relief, because they are dealt with on a case by case basis. So if you have questions relating to humanitarian relief, how can I get humanitarian relief? If you are eligible, we will answer the question and explain it. But generally, humanitarian reliefs are decided on a case-by-case basis. It is documentary evidence is considered, but it does not guarantee that if two people submitted exactly the same document, they were in exactly the same situation, it does not mean that both of them will be approved. One may be approved and the other may not, because it is on a case-by-case basis. That is one of the major differences of humanitarian relief. Okay, let me know once we start getting questions. So we are continuing, as we said, regarding coming to live and work in the United States. So today we are discussing humanitarian relief. So if you have questions relating to any of the humanitarian reliefs, you can send it in and we will answer it. Humanitarian reliefs, once again, includes asylum, includes deferred action, even DACA falls under humanitarian relief. The recent President Biden executive action for Iwi spouses of U.S. citizens, those are humanitarian reliefs. T visa benefit for victims of trafficking, those are humanitarian relief. Benefit for victims of crime, those are humanitarian relief. So if you have questions relating to any of these, how do I apply for this, or whether you want to know if you stand a chance, those are humanitarian. We can answer that as it relates to humanitarian relief. Those are the ones we are dealing with today. Now, when we say relief, it is the same thing as benefit. When you apply for something and it is granted, it's a kind of relief. It prevents you from being deported. It prevents you from being removed. That is why it is called relief. And it is also a benefit for you, because once you are approved, you get the benefit of the approval. That is also the reason it is called benefit. So I'm going to be using the word relief and benefit interchangeably, but technically they mean the same thing. So when we say humanitarian relief, we are talking about humanitarian benefit. Those benefits you apply for when you oh, somebody said, who is this? No, somebody said I need a lawyer, and another person said I can represent you, the same person.
No, someone else is quoting Big Boy and tell him that they can represent
Oh, okay.
them.
Okay, so okay, just let me know once we start having real questions. So now we continue with the humanitarian reliefs. If you have questions in that regard, you are free to send it in. Although we have discussed in some of our previous episodes many of these topics extensively. For example, we have discussed asylum extensively. We have several podcasts on asylum. We discussed each of the 5 eligibility requirements separately. We also have discussed T visa separately, extensively in a separate podcast. We have also discussed U visa extensively. So we have individual podcast for that. But because we are treating coming to live and work in the United States series, So it is important that we include humanitarian reliefs. So that is why we are doing that today. So if you are eligible for humanitarian reliefs, or if you want to know if you are eligible, if you have specific questions relating to humanitarian relief, then you are free to send in your questions. So we are waiting. This podcast is every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific. And of course, in Africa, that is 6 p.m. Nigerian time. So if you have questions, send it in. Call your colleagues at work, your family member, your friends, and let them benefit from this podcast. So we are waiting for questions on humanitarian relief. That is what we are discussing today. So in the meantime, since we don't, or do we have questions? Okay. So in the meantime, while waiting for questions, I want to take it one by one, talking about asylum. One of the major challenges that a lot of people have why asylum applications are denied is lack of understanding of what asylum means. Asylum is not asking the government to is not coming to seek refuge. Yeah, that is the common definition I get from people when I ask about asylum. People say, oh, asylum is coming to seek refuge. No, that is not what asylum means, because if you have a problem in your home country, it is the responsibility of the government of your country to protect you. It is not America's responsibility. It is not the United States government's responsibility to protect you. If you have challenges in your home country, it is the responsibility of the government of your country to protect you. So you cannot come to the United States to come and seek refuge, because that is not the responsibility of the United States government. However, if the government that is supposed to protect you, if that government is the one that is trying to harm you, yes, that is when you can come to the United States and apply for asylum. But even then, even if you have the evidence that the government is the one trying to harm you, you still have to show that the reason that the government is trying to harm you is at least one of 5 recognized grounds. Those 5 grounds are race, religion, nationality, membership in a particular social group, or political opinion. So in other words, you have to show that the government of your country is the one trying to harm you, or the government is unwilling or unable to protect you from the person or people trying to harm you. So then you also have to show that the reason that the government is trying to harm you is either because of your race, or because of your religion, or because of your nationality, or because you belong to a particular social group, or because of your political opinion. Then the third requirement, you must apply for asylum within 1 year of coming to the United States. So those are the basic eligibility requirements for asylum. So it is not about coming to seek refuge here in the United States, because it is the responsibility of the government of your country to protect you from any form of harm. So it is when the government that is supposed to protect you, when they are the one trying to harm you, that is when you can now apply for asylum, for as long as you can show that the reason they are trying to harm you is at least one of those 5 grounds: race, religion, nationality, membership in a particular social group, or political opinion. So that is as far as asylum is concerned. Uh, Deferred action. Of course, deferred action simply means that the government is going to suspend the consequence of you staying here without legal status. Maybe you have been placed in removal proceedings. So if the government decide to grant you deferred action, they can grant you withholding of removal, assuming you are already in removal proceedings. But if you are not in removal proceedings and you still want to apply for deferred action, there are some humanitarian deferred action. But as I said, when it comes to humanitarian deferred action, it is based on a case-by-case basis. So you have to, for example, somebody can apply for deferred action based on health ground. Maybe you came in here to visit, for example, and while you are here, you develop some health condition which requires treatment. And of course, going back home to your home country at that particular time without receiving the treatment may even be risky. So, for example, I've seen clients who came in here for holiday, and while they were here, they started feeling somehow and they decided to go to the hospital. And guess what? They were diagnosed of cancer. So, in such a situation, you have to be treated. So on the basis of that, something like that, you can apply for humanitarian deferred action. But again, it is on a case by case basis. Somebody may be sick or even diagnosed with cancer, apply for humanitarian deferred action, and it may be granted. Another person may be sick, diagnosed of the same cancer, and apply for humanitarian deferred action, it may be denied. Unfortunately, there is no room for appeal in this kind of situation. The only thing an applicant can do is to reapply. It is on a case-by-case basis. I've represented clients who are diagnosed with cancer and we applied and they were granted. And I've also represented clients who had the same cancer. Well, it may not be the same cancer, who had cancer and we applied and they were denied because immigration believed that it is not sufficient reason for them not to return to their home country. So it is on a case by case basis. No two cases are the same. So it is on a case by case basis and one can apply for humanitarian deferred action. Now, if you apply for that, if it is approved, then it will come with employment authorization. Once they approve it, they will issue employment authorization. So you normally will submit the application for employment authorization along with it. But but no, I think we can submit it along with it, but sometimes we submit the application separately after the humanitarian deferred action has been approved. I have done it together before in the past, and I've also done it separately. But generally, the employment authorization will not be granted until the humanitarian deferred action is approved. I see that we have a lot of questions now. I'm trying to see where the questions start from. I see a lot of hi, hey. Good afternoon. Oh, that is you. Okay, I want to assume that the first question is the one that says, when can I get work permit after applying for asylum? Is that the first question? Okay, well, it depends on whether you apply for affirmative asylum or defensive asylum. For affirmative asylum, you can only apply for employment authorization 150 days after your application has been accepted by USCIS. So 150 days. However, for defensive asylum, you have to wait 6 months, 180 days after your application has been accepted by the immigration court. That is the time that you can apply for employment authorization. The next question Oh, this one is talking about if Trump
Trump.
loses. That's
Oh, yeah.
not a question for this purpose. I'm afraid of being kidnapped in my home country because I have a lot of money and the gang knows it. Can I apply for asylum? No, that is not the basis for asylum. Gang kidnap is not a basis for asylum. So if you are afraid of being kidnapped, seek refuge with the government of your country. I'm sure every single country have security. They have police. Every single country have law enforcement officers. So seek refuge with the law enforcement officers in your country. That is not a basis for asylum. The next question: if I'm granted deferred action because of medical issues, how long will I get it? Well, as I said before, it is on a case by case basis, but usually they grant it on a yearly basis. So if you apply and they grant it, they will grant it for 1 year and they will give you employment authorization for 1 year. Of course, if your condition has not improved, you can always apply to renew it. So it is granted on a yearly basis, on a case by case basis. The next question, you should take your money. Oh,
It was in response to. Mhm. So maybe you want to clarify.
what do you mean by response? I don't understand it.
So he's responding to the one that Kimberly posted. He's thinking that it was Kimberly, the one that has the money, but she's just, transferring the question.
Okay, okay. He was responding to the person that said he has a lot of money. Oh,
Yes,
okay,
yes.
okay. The next question: if deferred action is granted, can I get a work permit? Oh, yes, I've already answered that. Once deferred action is granted, is usually granted on a yearly basis. Yes, they will also give you a work permit that is valid for a year. And of course, you will also get social security number and all of that. Yes, you can get that. The next question: what kind of evidence do I need to provide if I want to apply for asylum? Well, this is an open-ended question. It depends on the basis for asylum. I've explained asylum before in a separate podcast. I've also explained it even today. Again, asylum simply means that the government of your country is not able to protect you from the fear, from the harm that you have. Or the government is the one giving that harm. You cannot apply for asylum on the basis of a private threat. You cannot apply for asylum on the basis of your family threat. Asylum is basically saying that the government of your country is the one trying to harm you and you want America to protect you from the government. Or you are saying that someone is trying to harm you in your country and the government is unwilling to protect you from that person. Again, even if you meet that requirement, you still have to show that the basis, the reason why they are trying to harm you is at least one of five recognized reasons under American asylum law. Those five reasons are race, religion, nationality, membership in a particular social group, or political opinion. So if you meet any of these conditions, then that is when you can apply for asylum. Now, it depends on which of them you want to apply under. That is what will dictate what kind of document you need to support your claim. For example, if you are applying on the basis of religion, your documentation will have to show the kind of religion you practice, your country's posture on religion, and of course, why anyone will want to persecute you relating to your religion. And of course, what is the government response to the threat? Did you even report it to the government? Did you report it to the law enforcement in your country? What did the law enforcement do? So all those evidence is what you provide or present in support of your case. That will be different from if you are applying on the basis of membership in a particular social group. For example, some examples of membership in a particular social group include someone who is a victim of female genital mutilation. So if you are applying under that, the first thing you need to show is evidence that you are actually a victim of female genital mutilation. How do you provide such evidence? You can get a forensic examination done here in the US. They will examine you. Usually, what is that doctor that treats women?
Gynecologist or
Yeah,
GYN?
usually a gynecologist will examine you and write a detailed report. They will provide forensic examination and they will state what they find, whether you are circumcised, whether there were mutilations and all of that. Of course, in addition to that, you still have to provide evidence of your government's posture to female genital mutilation. For example, do they have a law making it illegal? Are those laws being enforced? What is the government determination or response to the threat or even the effect of the female genital mutilation? Did you report it to the government? Was police involved? All this evidence you have to present it. So it depends on what you are applying under. Another example of membership in a particular social group is sexual orientation. For example, if you are claiming that maybe the government of your country is persecuting you because you are gay, do they have a law that punishes people who are gay, or do they have other record of their posture, the government's posture to people that are not straight? So all those evidence you provide. And in addition, now let me say this: when it comes to asylum, you cannot get approved based on generalized information. You can only get approved based on peculiar information. Peculiar meaning that how does this affect you as a person? Not that you come up with general information. Oh, in my country, oh, they kidnap people, they circumcise people. Oh, in my country, they jail anyone who is gay. Yes, that may be relevant, but that is not enough for you to get approved. In order to be approved, you have to show peculiarity. What peculiar thing did the government do to you, or whoever is doing it for you or to you? How did the government respond? So you have to show how those things affected you personally, not generalized information. Very, very important. The next question: how can I get evidence if I had to flee my country? I fled with nothing but my passport. Of course, nobody drops down from heaven. Everyone have families, everyone have friends, everyone have I mean access one way or the other. I mean, there is no human being that just drop from heaven and come. Of course, you can get evidence through your family members. You can get documentary evidence. Your friends can help you gather evidence. For example, if you reported a matter to the police, I mean, you can send someone to the police station to go and request for a copy of the police report on your behalf. For example, if there was a form of attack and there are witnesses, even from here, you can call home, you can call people who witness it, and they can provide affidavit stating what they witnessed. So you can still gather evidence. So you don't have the fact that Of course, most people who fled, they don't have time to pick documentations and all that. But let me also tell you, even if you are in that situation, the US government is also aware of that sometimes you may not be able to pick one or two things. So they still have to look at your credibility, your story that you are presenting. Is it credible? They compare the story with public record. They compare the story with what they know, what the US government knows about your home country. So the Department of State, they write report, the human rights report on every single country on earth annually. So there's a lot of ways that you can still prove your case even if you ran only with your passport when you left your country. The next question: can the application for humanitarian deferred action be monitored? Well, I will say yes. Excuse me. But if you didn't submit it in time, of your application. The third way is if your application is denied, again, they will send you a letter explaining why the application is denied. So those are the three ways of communication once you file humanitarian deferred action. The next question: I was not aware that FGM was a grant for asylum until I saw your previous podcast. What protected grant will FGM be under? FGM is female genital mutilation. It is under membership in a particular social group. It is under membership in a particular social group. As I stated, for asylum, you can only apply under one or two, at least one of five protected grounds. Those five protected grounds are race, religion, nationality, membership in a particular social group, or political opinion. So membership in a particular social group, that is what female genital mutilation comes under. So there is a social group known as victims of female genital mutilation. So you come under membership in that particular social group. The next question: if I'm granted deferred action, can my family be included? Yes, your family can be included if your family was listed in your application. Of course, your family can be included. Even if your family is outside the country, they can apply for humanitarian visa if you are granted humanitarian deferred action. They can apply. Yes, your family can be included because most of the time, especially when people are applying for humanitarian deferred action based on health ground, generally they need somebody who will take care of them. So, and of course, your family will be granted humanitarian visa if they are outside the United States, but they will also be granted deferred action if they are inside the United States. The next question: hello sir, is this going on now? I don't know exactly what is he referring to. Whoever sent this question, I don't want to mention the name online, but if you send this question, hello, sir, is this going on now? What exactly?
His name is there. You can mention him too.
Okay, Mr. Olu Asekun, you send this question. Is this going on now? What exactly are you referring to? Are you referring to all the humanitarian deferred action that I mentioned? Yes, all of them are going on. All of them are available. If you meet any of them, if you meet the requirement for any of them, yes, you can apply now. You can still apply for asylum if you meet the requirement for asylum. You can still apply for humanitarian deferred action if you meet the requirement of humanitarian deferred action. You can still apply for TU visa if you are a victim of trafficking. You can still apply for U visa if you are a victim of criminal activities. Let me say this: for criminal activities, including trafficking, there is no expiration, there is no limit to when you can apply. It doesn't matter how long ago, even if whatever happened to you happened several years ago, for as long as you still have the evidence, you can apply at any time. It doesn't matter whether you are in status or you are out of status. It does not even matter whether you entered the United States with a visa or you did not enter with a visa. You can still apply for as long as you meet the eligibility requirement. So I really don't know what the question is asking, whether it's going on now, but all the humanitarian deferred action, they are all ongoing. They are still available for eligible applicants. The next question: are all these benefit programs available for all countries? Oh yes. Oh yes, they are available for all countries. It doesn't matter which countries. The only thing that may be different is the processing time. Processing time may be different.
How about the countries that North Korea, Russia?
It doesn't matter.
Doesn't matter.
Even from North Korea, you can apply for asylum. Even from Russia, you can apply for asylum. It doesn't matter. In fact, that will even make it more credible if you are running away from the North Korean government, or if you are running away from the Russian government. Yeah, there is no limit. Any You can apply. Citizens of every country can apply for any of these benefits.
Mhm.
The next question: if you have any
That's it.
Oh, I was giving the cell phone numbers for questions.
okay. The next question: are asylum seekers eligible for benefits such as SNAP, food stamps, and Medicaid? Yes, you all these humanitarian deferred, all these humanitarian benefits, you can apply for Medicare, you can apply for SNAP, you can for all these humanitarian benefits, not only asylum, for all of them, you can apply for benefits. Yes, it does not disqualify you from getting benefits in the future. The next question: can I bring my family members to the US if I'm seeking asylum?
Like the
I
person.
don't understand the question, but if the question is for asylee, can the family be included?
No, they're saying like they are applying for asylum.
They're already here.
They're already here. They are applying for asylum. They want to bring their family members because
If you are already physically present in the US and you are applying for asylum, you can only add your family after you have been granted. You cannot do that before your application is granted if your family is still outside the US. If your family is inside the US, you can apply together. You can include your family as your derivatives. But if your family is outside the US, you have to be granted first before your family can be included. That is the way asylum works. The next question: my family and I are here and we are seeking asylum. Can I enroll my children in school while the asylum is pending? Oh, yes. Oh, yes. You can enroll them in school. You can apply for any form of benefit you are eligible for. You can do any of those things while the application is pending. Yes, you can do that. You can apply for employment authorization, apply for social security number. You can do all of that while your application is pending. Yes. The next question. What is the difference between a credible fair interview and an individual hearing? Well, credible fair interview is not the same thing as asylum. Usually, credible fair interview is conducted only at the border. For people who come in and apply for asylum at the border, that is where credible fair interview is usually conducted. Now, credible fair interview precede asylum. It is not the same thing as asylum. It precedes, is a step before application for asylum is granted. Usually, when someone comes in through the border, and then you are telling them that, oh, I don't want to go back, I'm afraid, my life is in danger, I want to apply for asylum. So the question is, before they even give you the benefit, before they even give you the opportunity to apply for asylum, they want to know that the story you are telling them, are you even credible? Is it believable? Maybe you are telling them that somebody is after you, they want to kill you, they want to be sure that, is this even possible, is it reasonable? So they will, most of the time they will detain you and bring in an asylum officer who will conduct a credible fair interview. Now, if there is a favorable, credible determination, then they will now give you the opportunity to apply for asylum within 1 year of your entry. But if they look at it and they believe that your story is not credible, so they will just believe that it's a waste of time and energy and probably government resources, that no, you are not credible, so you just there is no point, you should go back to your home country. But sometimes, if you disagree with the credible fair determination, remember, you have not even applied for asylum yet. This is just a credible fair determination. So if you disagree with the outcome, if they tell you that, okay, we have determined, we have looked into your story, we don't believe that you are credible, you can challenge that credible fair determination in at the immigration court. Now, this does not involve removal proceedings. This does not involve issuance of notice to appear. This does not involve an application for asylum. What you are simply saying is that you disagree with the officer's determination that your story is not credible. So the judge is going to listen to your story. The judge is going to review your evidence, and the judge is going to make a determination whether your story is credible or not. If the judge concludes that your story is not credible, then you will be deported or removed right away. If the judge believes that your story is credible, now the judge will give you an opportunity for you to apply for asylum. You can now apply for asylum after that credible fair determination is made. So it is not the same thing as asylum. It is a condition to asylum. It's a prelude. I won't call it a condition, because it is not everybody applying for asylum that need to go through credible fair interview. It is only those who are applying for asylum at the border, either at the airport or land border or sea border. Anyone applying for asylum at the border, they are the one that have to go through credible fair interview before they can even apply for asylum. The next question: what happens if I apply for humanitarian deferred action and they deny it? I need to continue my medical treatment and I cannot get it in my country. Well, If your humanitarian deferred action is not granted, if you are really seeking medical treatment, I can guarantee you that USCIS or ICE will not have you deported. But again, if you continue your medical treatment, you can reapply, obtain letters from from your physician, the physician that are treating you. Let them write an opinion, let them write a letter and reapply for humanitarian deferred action. But if you are receiving treatment, I can guarantee you that you cannot be deported while the treatment is ongoing. In fact, in the United States, it is against the law for anyone to be denied treatment, whether you are legal or illegal, whether you have a removal proceedings or even you have a removal order. If you are in the hospital, you must be treated. That is the law of the land. So whether your humanitarian deferred action is granted or denied, it does not stop you from receiving treatment. But if it is denied, my recommendation would be get additional medical record, get the treating physicians, get them to write letters and explain your situation, and then reapply for the humanitarian deferred action. Remember, it does not matter whether you are in status or not, so you can always reapply. And I believe that if you have a legitimate application, it will be granted. The next question: is it possible to file for asylum even if I'm out of status? Well, you can apply for asylum when you are out of status. However, you can only apply for asylum within 1 year of entry into the United States. So, if you have been here for less than a year and you are out of status, yes, you can apply. But if you have been here for more than 1 year, even if you apply, you will be denied, because at the end of the day, it is one of the legal requirements for asylum that you submit your application within 1 year of entry into the United States. That is a mandatory requirement. So if you don't meet that requirement, your application may ultimately be denied. The next question: after asylum has been granted, how soon can I apply for green card? If your asylum application has been granted, you wait 1 year. After 1 year, anytime after 1 year, you can apply for your green card. It is not mandatory. You may choose to wait 2, 3 years, 4, 5. You may even choose not to apply. It's your choice. But the minimum period of waiting is 1 year. You wait 1 year. After 1 year, you submit your application for permanent residence. The next question: I didn't know I could apply for asylum and I'm sure I am eligible, but I've been in the US for more than 1 year. Can I still apply? Well, if you have been here for more than 1 year and you apply, it is only if you can show exceptional circumstances that delay the application. If you don't, if it is simply because you didn't know, of course, the application will end up being denied. Anybody can apply for asylum, but what matters is whether the application will be approved or denied. And of course, if you are applying after the 1 year deadline, it is 99% certain that it will be denied. The only 1% is for those who have extraneous circumstances, exceptional situation, something that prevents them from applying, or somebody who is applying based on changed country condition. For example, maybe you've been here and you have overstayed, and then maybe a war broke out in your home country and your family was targeted. Then you can use that to show change country condition and then apply for asylum, even though you have been here for more than 1 year. So they will take that exceptional situation into consideration in weighing whether to approve or deny your application. The next question: I'm applying for affirmative asylum. Should I also check the box that says I'm also requesting for withholding of removal? Well, asylum application and withholding of removal, they are not the same thing. The application that is used for asylum, that application form I-589, that application is used for three separate benefits. The, the first one is asylum application. The second benefit is what is called withholding of removal. And the third benefit is what is called protection under CAT, Convention Against Torture. So now, the requirement for each of those three are different. So if you believe that you meet the requirement of all three, yes, you can check all three. If you believe that you don't meet the requirement of asylum, but you meet the withholding of removal, yes, you can check only withholding of removal. Let me give you an example. I just explained that if you have been here for more than 1 year, you are not eligible for asylum. Now, if you are eligible for asylum and you are also eligible for withholding of removal, and you have been here for more than 1 year, because you have been here for more than 1 year, you are no longer eligible for asylum, but you can still apply for withholding of removal even though you have been here for more than 1 year, because withholding of removal and protection under Convention Against Torture, those two benefits, they do not have the requirement of 1 year filing deadline. Only asylum application has that 1 year filing deadline. So if you have been here for more than 1 year, you may not be eligible for asylum, but you may be eligible for withholding of removal. However, the standard for proving asylum application and the standard for withholding of removal, they are different. For asylum, the legal standard is it is more likely than not. In other words, you weigh the lady justice, and it is more likely than not that you will be harmed if you return to your home country. But that is not the standard for withholding of removal. Withholding of removal, the standard is higher. What you need to prove is higher. So you have to show that you will be harmed, not that it is more likely than not. You have to show that you will actually be harmed. So the requirement is higher. So if you are not eligible for asylum, yes, you may be eligible for withholding of removal, but the requirement for the legal standard for withholding of removal is higher. And of course, Convention Against Torture, that one also have a higher or different requirement. For Convention Against Torture, usually you have to show that you have been tortured, because that one is not based on speculation. It's not based on speculation. So you have to show that you have been tortured. So that even have a much higher requirement. So there has to be evidence of past persecution when it comes to Convention Against Torture. But when we are talking about asylum, it is more likely than not. So that is the legal standard. But if to go back to the question, I'm applying for affirmative asylum, should I also check the box that says that I'm also requesting for withholding of removal? Now, if you are applying for asylum within 1 year, yes, you can leave the box if you are applying for asylum within 1 year, because like I said, the standard is lower. So if you apply for asylum within 1 year, if you meet the requirement, there is likelihood that you'll be granted asylum. So you will not need to go into something that is higher. You will not need to go into a standard that is higher. However, if you are applying for asylum after being here for 1 year, then it is advisable to check those marks to also let the immigration officers know that you are also applying for withholding of removal, so that if they disqualify you on asylum based on the 1 year deadline, they can now consider your case on the merit based on withholding of removal. So yes, you can check it if you are applying after 1 year of here. But if you are applying within 1 year, it is not really worth checking those things, because if you cannot meet the requirement of asylum, which is lower, there is no way you will meet the requirement of withholding of removal, which is higher. So the next question, I am considered, maybe, am I considered to be legal if my application for humanitarian deferred action? If yes, how can I prove it if someone asks me for my...
If the application for deferred action is pending, they didn't transfer the whole thing.
Oh, okay, spending. Well, what I will say is that if you apply for withholding of removal, if you apply for deferred action, mail it in with something that you can track. Mail it in with a traceable or trackable method of delivery. Don't send it with regular mail. If you send it with regular mail, you will not have any evidence that you even have anything pending. However, if you mail it with a trackable mail delivery and you have a copy of your application, yes, you can show that as a form, as evidence of your legal status. So if someone tried to stop you or something, you can tell them that yes, I have an application for deferred action pending at this local USCIS office. They have a way of confirming whether the application is there or not. So you may not know, but they may know. At least when I say they now, I'm talking about CBP, USCIS, or ICE. I'm not talking about employers, because employers are not going to know. Even the police may not know, but if you have proof of delivery and you have copies, if the police don't know, I mean, it is not the police duty to enforce immigration law. If they have any issue, they will contact ICE. So, and ICE will be able to verify whether you have that application pending or not. So the only form of evidence you will have will be copies of the application and the proof of delivery that you will have with you until the application is approved. But while that application is pending, yes, you are lawfully present and you are protected. You may be in unlawful status, but you will be lawfully present, and then you will be protected from removal or even detention. What's the next question?
From Sudan.
Oh, I think I probably anyway, I've answered it. I omitted this question. What's the difference between asylum and withholding of removal? But I think I've answered the question. I mean, I've explained that the requirements are different. Yeah, I've answered that. So let me go to the next thing because it's already 1 o'clock. I'm from Sudan, and because of the war, I had to come to the US. Is this enough to apply for asylum? Well, it depends on a number of factors. It's not a yes or no answer. It depends on a number of factors. Number one, if there is war in Sudan, the first question is, has your family been targeted? If your family has been targeted, was the reason they were targeted one of the five bases: race, religion, nationality, membership in a particular social group, or political opinion? If the answer is yes, your answer is yes, you can apply for that. For example, most civil wars, the race is usually an issue in most civil wars. It may be that some tribes are fighting against another tribe, so race or nationality may be an issue. So if that is the case, you can apply for asylum. But if you do not meet any of those five: race, religion, nationality, membership in a particular social group, or political opinion, if you do not meet any of those five, then you may not be eligible for asylum, but you may be eligible for TPS, because generally when there is war, American government always grants temporary protected status for victims from those countries. So, and I'm sure that there is a TPS for Sudanese. There's a TPS from people from Ukraine. Usually when there is a war, American government always grant temporary protected status. That is different from asylum. So if you meet the requirement of asylum, yes, you can apply. But the fact that there is a war by itself is not enough. That may be enough for TPS, temporary protected status, but it may not be enough for asylum. For asylum, you still have to show that, one, your family was targeted, or that the reason for the war in the first place is because of at least one of those five: race, religion, nationality, membership in a particular social group, or political opinion. The next question: if I've had an asylum application denied in the past, can I still apply for asylum? Well, if you meet the requirement, yes. It doesn't matter if you have it denied in the past. You may not be eligible in the past and be eligible for now. And let me say this: even if you are here in the US and you have been denied before, if there is a change country condition, I mean, just like this example of war that we just talked about, if there is a change country condition, yes, you can still apply. For example, let's say, which country should I use now? Okay, this is just an example. Let's say you are from Nigeria, you are here in the US, you apply for asylum, maybe on the basis of political opinion. Your asylum application is denied. Generally, they will send you to removal proceedings for you to go and represent your asylum claim before an immigration judge. Now, maybe you presented it to an immigration judge. Maybe your asylum is denied. Maybe you are even ordered removed from the United States, but you didn't leave. You remain here and you have not been removed. Now, maybe there is war in Nigeria, and maybe the war, for example, maybe the northerners, the Hausas or the Fulanis, maybe they are killing the Igbos in Nigeria on the basis of nationality, and maybe that led to civil war as it happened in 1966. So maybe something like that happened. Even though your asylum has previously been denied, even though you have been ordered removed, you can still go back and file a new application for asylum. Because you have been ordered removed, you will file it with the immigration court with evidence of change country condition, and you file a motion to reopen the removal order, and for the court to reconsider your new asylum application based on change country condition. Yes, you can still do that. I think the last question, what happens if my asylum case is denied by the asylum officer? Well, I think I just touched that answer in my previous answer. Generally, under the United States immigration law, for affirmative asylum, now let me explain what is affirmative asylum. When you submit your asylum application to USCIS, United States Citizenship and Immigration Services, and you are not in removal proceedings, you are not in deportation proceedings, that is called affirmative asylum. Now, if for any reason you have been placed in removal proceedings or you have been placed in deportation proceedings, and after that you decided to apply for asylum, that is called defensive asylum. So for affirmative asylum, that is application that you submitted to USCIS without you being in removal proceedings, if that application is not approved, USCIS officers do not have the authority, they do not have the legal authority to deny affirmative asylum. And because they cannot deny it, the law mandates them to do only one thing: to send you to removal proceedings, to go and meet an immigration judge, and for you to go and represent your asylum application so that an immigration judge could look at it much clearly. So now, if that happens, you will now be in removal proceedings. Notice to appear is going to follow it. So it is not the same thing as affirmative asylum. Now, you will now have to present a defensive asylum. Defensive because you are now in removal proceedings. Because now, if the judge does not grant your asylum, the judge is probably going to order you removed. So at that stage, you have to be defensive. You have to defend yourself from being removed from the United States. So it becomes a defensive asylum. But for affirmative asylum, immigration officers can only approve it if they believe you. If they don't believe you, they cannot deny it. The only thing they can do is to send you to an immigration judge. And I believe that we are going to have to end this segment today, and we intend to continue next week by God's grace. So, again, remember to invite your family, friends, colleagues at work so that all of them can also benefit from this wealth of information that we share every week. So, until then, I remain Olu Asekun. Our podcast time is 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. It is 1 p.m. Eastern Time. It is 10 a.m. Pacific Time. It is currently 6 p.m. Nigerian time. So we hope to see you again next week. Have a wonderful day. Bye.